All right, so let's get to business. We are going to start off with a presentation on pretrial release alternatives. I plan to put forth a bill, and this presentation is just for us as members to get more information. So I would like to start by recognizing Edward Perry to present. If you're here, you may come up to present.
Good afternoon, Mr. Chair. My name is Lanard Perry, Edward Lanard Perry. I go by Lanard. It's a pleasure being here today. I'm also humbled at the same time. I do have a presentation that I'm going to be going through, but I will take some liberties and deviate. I understand my speaking time is about 10 minutes. Is that correct? More or less?
Feel free.
Okay.
I'll let you know when it starts going. And make sure your microphone is on. I think it is, but
it is.
It's okay.
Can you hear me okay?
I can.
Okay. So I'm from Alachua County, Gainesville, Florida, and I work with the Alachua County Department of Court Services. And in our county, we have an array of pretrial release programs and services that we work closely with our judiciary, our state attorney, Bill Savone, and Public Defender's Office, Stacy Scott. If you'll see on this particular page here, and it's too small for the audience to see, and I apologize for that, there's a designation of CPSP, Certified Pretrial Service Professional, is what that means, and it's issued by the National Association of Pretrial Services. I'd like to start with a quote, which is, "Who is in jail should be a public safety decision driven by risk, not a business decision driven by profit." And I think most folk in the room can attest to the fact that the bail industry is a pretty profitable business. I don't begrudge anyone a livelihood, but in the criminal justice system, I think that there's a lot of room for minimizing bail releases and maximizing RORs, release on recognizance. In short, my position, and I think it's the position of many folk who work in pretrial services, that the bail system does not address public safety. Someone with a $500,000 bond, for example, who may have committed murder, and I apologize for the graphic language, but if they have the money, they can get out. That money bond release does not ensure that the community is going to be safe. So it doesn't ensure that the communities are protected. On the reverse end of that, folk who can't afford to get out sit in jail. And oftentimes there's great harm to their family, their careers, etc. And sometimes those charges and their violations are minor in nature. There is a science that's capable of predicting who's a good candidate for pretrial release and for who should be held in jail pending trial. And the tool that is used for that is a pretrial risk assessment tool. That risk assessment tool assesses a person's risk to return to court, appear to court, when they're supposed to, by looking at a number of factors. Age at time of admission, their current most serious charge, prior failure to appears, their most recent and number of felony convictions as well as misdemeanor convictions. We also look at any history of substance abuse or mental health issues, and in the end, what we do is we take all of that information, we break it down to a number, if you will, that is broken down and assessed as a high, low, or medium risk of risk to the community and likelihood to appear to court in court when they're supposed to. I would submit that high-functioning pretrial release programs are a low-cost answer to maintaining pretrial defendants pending case disposition. Again, for the audience behind me, they can't see this very well, but in Alachua County we have an array of programs and services, starting with our pretrial services first appearance process. In the first appearance process, we have staff who interview everybody who's in jail prior to going to first appearance the next day. They gather that information and all of the information that I just got through describing, and they then make recommendations to the judge about the likelihood of them returning to court when they're supposed to. We share that information with our state attorney's office as well as the public defender's office, and then ultimately the judge is going to make his or her decision about what they think is the best thing to do. Our programs, compared to incarceration alone, they're not only low cost, they are pretty effective. They're low cost in the sense that just about in any jail you go to, in Florida perhaps, I would say, the cost per day is going to exceed $100 per day to keep someone in jail. That certainly is the case in Alachua County. If you look at our programs and services on this screen, the highest cost per day for any of them is $17, almost $18, and that's for our work release program. The next highest is for our metamorphosis program, which is a long-term residential substance abuse treatment program. So with our pretrial services program, we operate at approximately 41 cents per day per person. That's pretty low. And we do that without compromising safety and security to the people who reside in the community. We have a high rate of court appearance, which is about 90%. And we have a high rate of safety while they are released to us, which is approximately 90%. That safety release rate means that they haven't gone out and recommitted any new offenses while they were under our supervision. They go to court, and the judge is going to make his or her determination about whether they're going to release to our supervision or not, and they come into any of our various programs. Oftentimes with those decisions comes a requirement to attend programs and services that will assist them with getting their lives back on track. Someone with a substance abuse history, for example, might be court-ordered to substance abuse treatment. Someone with a mental health issue might be court-ordered to mental health treatment. Someone with anger management might be court-ordered to a batterer's intervention program.
Real quick, I wanted to ask a question, and
Yes,
members, if you want to ask a question, feel free to jump in. But you mentioned that safety is not compromised and that you have a high rate of court appearance. If you can just touch on briefly how you all ensure that happens.
Well, through our various programs, depending on how a person rates through the interview process, risk assessment, high, medium, or low. If they are low risk to the community, we may have them reporting in to see us once a week, for example. And that might be enough to keep them properly supervised and enough time to monitor whether or not they are adhering to the other requirements of their release. For someone who is a high risk, he or she may be put on electronic monitoring, placed on house arrest, and or placed in a secure facility like the work release program. So that's kind of how we do it.
Okay.
So our goal is to promote court appearance and public safety, which is what we do, and we do focus on risk management. I have a slide, Science of Pretrial Risk Assessment. We're about defining the risk. We look at a defendant's likelihood of missing a scheduled court date. and or arrest on a separate criminal offense. I've already addressed that. Our court rate appearance is 90%. Our safety rate is about the same thing. We assess the risk based on this actuarial tool that we just got through talking about, which is our pretrial risk assessment tool. And basically it replaces the subjectivity that goes into determining whether or not someone should be released. By objectifying it, if you will, by applying a numerical value to it, if you will. We ask the standard questions, we then get a scale that indicates whether or not they're likely or good candidate for the programs that we have in mind. Now, there will always be a need for human input and judgment, and that is where our supervisors come in. In our system, we have a team of folk who sit around at first appearance prior to going to court, and they look at the criminal history of everybody who's been arrested. They do background checks. They check to see how long a person has been residing in the community, whether he or she is employed, how long they've been employed, and the like. Collectively, they come to a recommendation that they present to the court. Our supervisors are involved in that assessment as well. If the team comes up with a recommendation that is different than the supervisors, he or she, actually a she in this instance, would have consultation with them, and they will vet out what the differences are and make a unified recommendation to the court. So, in addition to helping the court to make informed decisions about release conditions and releases and bail decisions, we ensure that the release options are realistic, enforceable, and measurable. When someone comes to us from court, we sit down with them one-on-one individually. We create individual not treatment plans, but individual case management plans, and get their input, their involvement, their commitment, and we have them sign off on it, and we hold them accountable for everything that they have agreed to and are required to do. So, from our perspective, it makes sense to promote pretrial release options, appearances, public safety, and compliance outcomes are part of what we are managing daily. The options could include anything from I apologize. I was about to repeat something I've already said.
No worries. You're doing great.
Okay. Pretrial services ensure the management of essential and interrelated functions under a single organizational structure and mission. We in Alachua County are a freestanding pretrial service program. We don't operate under the judiciary, and we don't operate under the sheriff's office. We're freestanding. And in that regard, we feel that we are empowered to protect the community to the degree that we are required, while advocating for folk who may not otherwise have voices. It's not uncommon for people who are in a pretrial status to be in jail. About 60% nationally of people who are in a pretrial status are sitting in a jail. In Alachua County, that's about 70%, so we're higher than the national norm. In our community, it's not unlikely to have a lot of folk who are sitting in jail on a $5,000 bond, or that's oftentimes they have minimal charges, are not a high risk to the community, are likely to return to court, but they still have this bond that is unattainable. They oftentimes, what I've seen in our system is judges, out of what they have shared as good-heartedness, will give someone a $500 bond. That's a great sounding number. A problem with that is someone who's poor, who's faced with a $500 bond, can't pay it. Oftentimes, bondsmen won't bond someone out with a bond that low because there's not a lot of profit in it, and the risk isn't worth the little bit of profit they may get. So a person on a $500 bond will sit in jail for a while. Average length of stay can be something like 45 days that they're sitting. Well, in that 45 days, they will lose their job. They will lose their apartment. They will lose their house. They may lose their family. And they may become non-compliant with other expectations. And so many of them will sit there. I think I can go up to $5,000 or $6,000 or $7,000 or $8,000 with that same amount, with that same scenario. So the system is skewed in the sense that if you have money, you can get out. If you don't have money, you won't get out. And a cycle of recidivism can occur at that point in time, because people who are released from jail without resources can become desperate and find themselves back in the criminal justice system again.
Yeah, Senator Baxley has a question.
Thank you very much. You were mentioning earlier that you were a freestanding organization.
Yes, sir.
Could you fill that in a little bit? Or, I mean, how are you funded? Who do you answer to? How freestanding are you?
We are a department under the Board of County Commissioners. And so we answer directly to the Board of County Commissioners. Some agencies, like ours, might report to a sheriff. And some might be under the court system. So we're kind of freestanding in that regard.
Follow up.
Yep.
Thank you, sir. So, what you're funded by the county commission, by the taxpayers. What is your budget to operate a county like Alachua County for this freestanding service from the county?
Our program runs about a little bit less than $6 million a year, approximately. And that includes a work release program, probation, our pretrial services program that I've just gotten through talking about, a residential treatment substance abuse program, a drug court program, a mental health court program, a veterans court program, a community service program, and a day reporting program.
Okay, another follow-up question. If someone's posting bond instead of this pretrial program, what would be the cost differential there? I mean, on that element alone, would it not be more cost-effective just to post people's bond for them? Or would you still spend $6 million and post bond?
Well, there is some thought about creating programs that assist people with bonding out. In Alachua County right now, that is one of the programs that an idea that we're looking at. So the answer, if I understand your question correctly, the answer is yes, there is a whole lot to be gained from a program like that. I'm just going to pick a number to talk about the example as I understand you'd be asking the question. We have $1 million sitting over here that we can tap into to bond out folk who are sitting there in jail on $500 or some such number, yes, makes absolutely a lot of sense, because every day that they're sitting in jail is running up $100 a day tab. $500 versus an average length of stay of 45 days at $100. So yes, there is some cost benefit to that.
Okay, and I just have one more question, if it's all right, Chairman. You mentioned a $5,000 bond for a minimal or nominal offense, you said? What kind of minimal or nominal offense would create a $5,000 bond?
Well, I'm going to give you my answer, but I'm also going to defer to the professionals from Alachua County. So a bond is set and determined based on a number of factors: a person's criminal history, how often they've been arrested, what they're currently there for, appearing before court for on that particular day and time. And sometimes a bond is not necessarily about the charge that's being presented as much as an accumulation of what their history suggests. So there's that.
Thank you.
Yes, sir. There are several states that have gone to no bond releases: Kentucky, Illinois, Hawaii, Vermont, some federal courts, Virginia, Colorado, Nevada, and West Virginia. When I first got involved with pretrial services about 3 years ago, I attended a training where one of the presenters was a judge out of D.C., Judge Morris. And in the D.C. area, they've been without a bail system for a while now. And it's been quite successful, and it's a model that many jurisdictions are looking at emulating. So, to start winding up, we're all about managing risk. We do that through supervision. We do it through monitoring their activities, by having them report in, by doing job checks, home visits, and by supporting them, while at the same time we're holding them accountable for what it is they're required to do. We help to ensure their success through, once we've identified their needs, integrating what their areas that they need support in through, again, substance abuse, mental health counseling, job placement, etc.
Mr. Perry.
Yes, sir.
Yeah, I'm going to ask you to wrap up because we have another presentation and we have a couple bills.
Outstanding. If I may, one. So I start out by asking who's in jail should be a public, making a statement who should in jail should be a public safety decision driven by risk, not a business decision driven by profit. And I appreciate your listening. Thank you.
Absolutely. Any other questions? Thank you for being here.